Hello there, good evening and welcome to this live discussion. Those of you who are joining us on television, a very good evening to you. And those of you who are joining us on Facebook, good evening to you as well. I'm joined in studio this evening by two of the commissioners of the Ghana Elections Commission, Mr. Robeson Ben and Mr. Sayes Conraj. Gentlemen, welcome to the program.
Good evening.
Good evening. Thank you.
All right, so there has been quite a lot of activities at GECOM over the past few months since the passage of the no confidence motion. Almost every meeting there are developments that are taking place. And I understand today's meeting was one such meetings where you had a number of decisions taken. What I'll do before we get into those decisions, I want us to address an issue that has been out there in the past few days with regards to the data that was accumulated from the house-to-house registration. There seemed to be some confusion, some conflict in terms of ideas, how you move forward with that data. So I'm going to invite you guys to first address that issue before we get into the decisions that we're taking today.
Well, Eddie, first of all, you said that there was some confusion. I want to say there is a lot of confusion on the ground in relation to the data that was posted. I want to say as well, surreptitiously, over the weekend. Now, this house-to-house data, as you're aware, the entire exercise was truncated by an order of the chairman. That being said, the data that was collected, there is so much confusion regarding the use of that data. Confusion both within the Secretariat and outside of the Secretariat among the citizenry of this country. The stated intention, as you'd be aware as well, the whole intention of the house-to-house process was to remove persons from the list, from the National Register of Registrants, and to create, in fact, a new National Register of Registrants. That was deemed to be unlawful by the Honorable Chief Justice in a decision that is now very famous that I don't even need to speak about. Now, all along, we have spoken in the Commission about the use of that data. First of all, there is nowhere in law that caters for the use of that data. Absolutely nowhere. Second of all, there is nothing in the law that caters for the posting of that data. Thirdly, there is nothing in law that caters for what must occur during any scrutiny of that data. But assuming that all of this was somehow countenanced in the law, what the government commissioners want to happen is for this data to be treated as though it is part of the preliminary list of electors. But this is what happens when a preliminary list of electors is being posted. First of all, it is a scrutineered event. That is to say, it is posted in the presence, it's posted by GECOM officials in the presence of scrutineers from the two parliamentary parties. That was not the case with this posting on the weekend. It was done very clandestinely. People did not know that it was being published. Second of all, the public has not been notified that this data is in fact published and out there. Even if people get wind of the existence or publication of these lists, the posting of these lists in public places, at registration offices, etc., people do not know what to do with that data. They do not know, they have not been informed as to what steps they must take if they actually go, look at some place, find their name on that list, do not find their name on that list. There is absolutely no information available out there as to what a person must do vis-a-vis that list. And the reason for that confusion is that there is no grounding in the law in relation to what must happen with that list. Today, at the commission meeting, I inquired from the Secretariat, I inquired from the chairman, what must the person to do? What must the person do? I asked whether the purpose of posting the list It was for it to attract the elements, for it to for people to go and look at the list and smile, because as we speak, no one knows what to do. There is no procedure set out as to what must happen with that list.
But let me ask this question, Mr. Ben. I think you can come in here to address this, because you have the list that is generated from the truncated house-to-house registration process that is posted. Then you have a preliminary list of electors that is extracted from the National Register of Registrants that is also posted for the claims and objections exercise. You have persons who would have registered, who were on the NRR, who may have registered again during that exercise when they were told that they have to get new ID cards and so forth. Now, how, and I think this is what you were getting at, how do they treat, which list should they look at? How do they deal with their names on two different lists? How do you address this?
Well, in the first instance, I don't think there is any way in which you can post two lists. One, first of all, the PLE, and then alongside it, this list from the house-to-house registration. I would advise persons only to go to the PLE, and if they do not find their names on the PLE, then they should make a claim or an objection according to their particulars for the purposes of voting. They must go to the PLE. The list from the house-to-house registration is, in my view, illegally posted. There is no arrangement, there is no way legally, and this is the lawyer here, by which such a list could be posted. By my understanding, the law provides for supplementary lists to be posted, and a supplementary list could not have the names of persons of this house registration data, which already exists on the PLE. So the posting of this list is not the posting of a supplementary list. And since it is not a supplementary list, in fact, it opens the door to challenges, to petitions in respect of why it should be posted up there and in respect of the elections. I think we're entering a minefield, as I suggested today. So the list should not be posted in any event. And I believe that the Madam Chair, with all due respect, with this matter and a few others, is being misled. Is being misled not only by a wayward commission, because if there's an approach that is suggested by the chair for the purposes of her making a voting position, it should be advised too by the legal persons in the commission and by the CEO and others who have knowledge of this. And the laws are there, which should be examined to make sure that things are done properly. So I think in many respects, people are sitting down there and allowing the Madam Chairperson to make serious mistakes. And otherwise, on the other side, persons are throwing up things which we know in any event would have brought trouble. We knew that when we undertook the house-to-house registration and we matched the data from that against the NRR or the PLE, whatever, we would have had a tremendous number of duplicates, running into hundreds of thousands, 150,000 or more duplicates. Those have to be investigated. And we spoke to this problem earlier, but people are sitting back and allowing arguments to go forward without properly advising the Madam Chairperson as to what the law allows for and what is practical. The only persons who could be added to the PLE are those who would have turned 18 by December 31st of this year. In fact, those are the persons. Other persons could make changes to their particulars if they were missed. They could make a claim, or if they made if they have to do a transaction, whether there's a name change due to marriage or relocation, due to address changes, those changes can be made. But you cannot put up lists where thousands, tens of thousands, run into 100,000 or more people to have persons come to investigate those lists to see whether you appear on one list or the other. And all of this, when I say it's a wayward commission with secretariat really, with persons on one side who are encouraging ways by which elections could be delayed all along, is why we are in difficulty. We are wasting a tremendous amount of time on issues which I don't even have to say legally self-evident. They're self-evident by the mere reading of what the law is. We had a situation recently in respect of this very issue where Commissioner Corbin suggested that the word may, which is in the law, should mean shall, by the positions that he took, that may should become shall, and that any should become all, in terms of all persons who the Commissioner of Registration could call to examine a list or to be put on the list or to be taken. And so that's the kind of difficulty we're in. And I'm saddened to some extent by what is happening, by what I best can say is the misleading of the chairperson in relation to certain critical decisions that are being taken, and which leads to a lot of time wasting too.
Sis, I think you want to
So
comment.
yeah, you see earlier on, Eddie, when I spoke about confusion being festered both inside and outside of the commission. Another issue, you mentioned that the person may appear on two lists. But let me quickly give this example of how confusing this process can be. A person might have existed on a PLE, on the existing database. During the house process, they would have been registered again, perhaps at another place. When that PLE is posted, as it is currently posted, they check, they don't see their name there. They conduct another transaction. So you have one person for whom 3 extant transactions exist. What happens there? That is the kind of confusion that is being suborned by this cumbersome process that will ultimately lead to confusion come election day and confusion come during the electoral process. But speaking of confusion, with your permission, I'd want to segue into another process that is certainly, if this is not a recipe for disaster, what I'm about to tell you will be a recipe for mayhem come election time. Another decision that was taken today, with, of course, the concurring vote of the chairman, pursuant to a motion that was brought by the government commissioners, is a decision to remove persons, and I'll detail the process in a second, who have failed to collect their ID cards subsequent to registration. The decision is that if you are registered and you have not collected your identification card from the Guyana Elections Commission, your names will be published in the newspapers, you will be given 21 days, and I believe a registered mail will be sent to your home.
Yeah.
And if there is no response to that advertisement and that registered mail, then your name will be removed from the official list of electors, and you will thereby be deprived of the right to vote come elections day.
But if I can interject there, sis, I want to ask a question, because this somehow is a bit confusing on two fronts to me. One, the recent ruling by the Chief Justice, which says once the person is on the NNR, there is no way to remove the person unless that person is dead or disqualified for some way or the other. And the other one is that the chair, you're saying, voted that if the person doesn't collect their ID card, then they will be removed after going through this process of the register mail and so forth. How does this if you have to look at this and the decision taken by the chair when she was a sitting judge for the 1997 elections.
Well, that is exactly where I was going. The very person who now occupies the chair as chairman of the Guyana Elections Commission sat as the judge in the elections petition of Esther Pereira and vitiated an entire election because of the unlawful imposition of a requirement for persons to have in their possession a voter identification card for the purposes of voting in the 1997 elections. This same judge, who now sits in that chair, is ruling that a requirement for your inclusion on the list must be that you would have collected your identification card and have somehow proved your identity. The law does not cater. Article 59 and 159 of the Constitution of Guyana states very clearly the requirements for a person to vote. Those articles state extremely and pellucidly clearly what the requirements are. This is tantamount to an imposition of an additional requirement on a person to vote, and in my view, without more, is illegal and unlawful.
How does this conflict with this Chief Justice's ruling, though, with regards to removal of names?
Well, the Chief Justice's ruling is just a further step or confirmation of what the position is. You cannot willy-nilly remove a person or disenfranchise them from voting, and that is exactly what is happening here.
And the numbers in terms of ID cards, I think...
It's in excess of 25,000 persons who stand to suffer a detriment as a result of this ruling.
So I voted in the last election using my passport. I had my ID card on me. Is it we're seeing the commission heading in a direction now where you will be required to produce your ID card or so?
So I don't want to preempt what direction the commission is heading in, but I know for a fact that it is not a requirement to present, in fact, any form of identification in order to vote. A person can turn up, as we say on the streets, with their two long hands
and be identified.
We have put steps they will in place in the polling stations to deal with these issues. But you take a note of identity, etc. There are other forms, secondary forms of identification, etc., that you have to go through so as to allow you to vote without being in possession of your national identification card. This step, which really is a failure of a person might have failed to collect their identification card for a myriad of reasons, none of which are material at this point. None of which are material at this point. The fact is you are lawfully registered, and that is all that matters. Because, remind you, in order to be registered, you had to have gone through a process. You went through that process, a legal process. You were entered into a national register of registrants, and you are now saying that that person will be removed therefrom.
From the PLE.
You will be deprived of voting because your name will not make it to an official list of electors.
Where do we go from here?
Well, the strange thing is, in respect to this issue, is that if in this 21-day period you happen to go to Trinidad, or you're in Amrina and walk about, as I like to say, in the interior, and you can't go and collect the ID card, and newspapers don't get in the bush anyway, so you mightn't see the name listed. Or you may not have an address to which any post person goes to. Your name will be removed because you would not have responded to the advertisement, you would not have collected the card, you may not even be aware of the process. But once the 21-day period has gone by, your name will not be on the official list of electors. And this plainly could not be right.
Just that is based on your explanation, is clearly a violation of a basic human right, the right to
a violation of the Constitution of
and
Guyana.
the Constitution to elect your own leaders, or it's in contradiction to the ruling of the Chief Justice. But you talked about one decision that was taken today, and I think a lot of people are going to be concerned with that decision.
So those are two decisions. Well, that is the seminal decision. The other thing is the confusion in relation to the use of the house-to-house data and where we are. There is confusion, like I said, within and without GECOM in relation to this matter.
Let's talk about scrutiny of the process leading up to the elections and the elections itself. I know there are proposals, there are recommendations to have observers, international observers, both at GECOM prior to the elections, during the elections period, and probably after the elections. The commission met today. Was this discussed, and what was the decision taken?
Well, Eddie, as you was a matter of public notoriety, we met last week with a delegation from the European Union, which is really an exploratory mission to field an electoral observer mission come elections. But you see, scrutiny of elections is much more rather than just having an electoral observer mission which may last for a shorter period. Scrutiny during elections, during and after, requires expert scrutiny, technical advice and technical assistance of the processes that comprise the electoral cycle. In that regard, a decision was taken earlier on that every offer we have for technical assistance must be accepted, so as to broaden the scrutiny of our processes, with the intention of having the results of the elections being generally accepted by all stakeholders. In this regard, we have received assistance, offer of assistance from Canada in the person of Jean-Pierre Kingsley, who was a former head of Elections Canada, the equivalent of GECOM. He has come, he has met with the commission, he has met, I understand, with the secretariat and so on, and is expected back. He is now in the critical process of analyzing our processes, etc. We have received an offer of assistance from the Commonwealth Secretariat, and they intend to send two very former senior elections officials from Ghana and India to interact with us. Today we have received terms of reference, etc., and some of their biodata from the Commonwealth Secretariat, and we expect those persons to be here imminently because time is of the essence. But what is very curious, we have read reports in the media about the United Nations through one of its agencies offering specific support in terms of IT and its related functions, and that offer of assistance apparently is somehow being obfuscated or refused for some strange reason. We have, like I said, we have read extensive reports, etc. And when this issue is raised at the commission, it is being skirted about. In fact, it is being flatly denied by the chair and the CEO that such offer was ever made to the commission. And it is strange. It is without reason, and in fact very perplexing as to why this specific offer is being skirted around, and it's anyone's guess as to why that is happening, because the intention is to have scrutiny at every possible aspect of our process to ensure that the integrity is without fail and question.
So was it discussed though again today with regards to?
It was discussed again today, and happily we have not come to a position on it properly. I think somehow at the end there's the position that in principle we want to have the persons from the Commonwealth Secretariat, in respect of the persons from the United Nations Development Program, that organization, again, they're running scared of that. And this started not just now, but it started with the former chairperson, whose name I need not mention, who contrived some way to make it appear that the UNDP persons here had made a misstep and had not followed the protocol in respect of their representations to come and help the GECOM and in the information technology area. I have again stated my position that the only reason you wouldn't want persons to come to provide support, technical advice, proficiency, experience, and even redundancy in that area is because you perhaps want to allow openings for things to go wrong. I mean, we can't talk about the time in which it takes to bring in the returns, and to collate and to put all of those things together if you don't have proper control and management over the IT. And you need every scrutiny in that area. We know that today, in the form of information technology, is one of the prime areas where attempts are made to steal elections. Kenya had the problem. The examples are replete out there from various countries where this happens. But there are certain critical areas, and the IT is the one area where you need that kind of support, technical oversight, unbiased help in relation to the operations there. And there is a concerted attempt to make the UNDP people here look bad and to suggest that there is no need for the UNDP people or persons in relation to this matter in the IT area.
All right. So the other question, you had this meeting today. You talked about the issue with the list. You talked about the decision to the chair voting in favor of removing names of persons who may not lift their ID cards within the 21 days. What are some of the other decisions and discussions you had at the level of the commission? Because I'm getting the sense, and I think Guyanese are also getting the sense, that there's a lot of confusion, there's a lot of loose ends, so to speak, to tie up if you're going to head into the elections in a matter of just over 3 months or so.
Well, Eddie, at this time in a preparation process for elections, the road, it's funny that the name of this program is On the Road to Elections 2020. The road should not be cluttered with so much of unwanted traffic, so to speak. And at this point, the destination should be clearly in sight on a road that has very few turns and very few obstacles. As we are now, we are traversing a very twisted path that is littered with perhaps debris, unwanted traffic, and lots of other things that really should not be on the road. We should not be, and elections are due what? 3 months?
3 months, just over
from
3
now.
months.
We should not have to deal with such what under normal circumstances would be non-consequential issues. But we seem to be dealing with issues that are contrived to obfuscate the process. They are contrived to confuse people out there. They are contrived to confuse people within the commission. And it makes me wonder, it makes me worry as to what the overall intention of such actions are. Because clearly they could not, the conjoined effect of all of these things could not be to have free, fair, and credible and elections that are free from fear in a timely manner. it makes me wonder as well which one of the bogeymen will be pulled out to affect this process, because there are too many that are being thrown along the path.
How do we go forward from here, Mr. Ben?
Well, it's a struggle. We are in a struggle to ensure free and fair elections, to make sure that the democratic process in respect of the elections are brought to bear and occur. The difficulty we have, I believe, is one, the representations on the other side, because they seem to be battling hard to adopt positions which are clearly illegal and unworkable in terms of the process. The other difficulty is the GECOM problem. I am still of the view that GECOM's operatives are largely captured by the other side, either out of fear or that they're willingly cooperating in respect of certain actions being undertaken or allowed for or not commented on in the proper way. Even in the way of advice to the chairman, as I've been speaking, because there's no way that a chairperson of a commission with all the experts in every area, their legal, technical, IT, and so on, could be making these mistakes. And the only answer for that problem is because people want things to go badly from GECOM itself, or they're being imposed upon from outside to go along ways which will delay, confuse, create fraud, create problems, and let us have great difficulty at these elections. So the important thing is, and this will help, the help will come from the oversight from both national and overseas observers who would have to be clued in as to what is going on, is that we have to bring back GECOM to being a professionally run, professionally managed operation, secretariat, agency. That is the task, to get them to do things properly. At the end of the day, GECOM itself should not be faced with the blemishes that we had in the 2015 elections, where they were stuffing the ballot boxes, where the returning officers disappeared, where the information didn't come in time, where the ballot boxes were not recounted when they should have, where even up to today, the elections petition from 2015 has not been attended to by the courts, by the judiciary, and where there's no report on the elections from the Guyana Elections Commission, from the Commission of Elections.
Gentlemen, I want to thank you very much for being here. You want to share something else before we go? Say
You asked the question, Eddie, where do we go from here? It's a very simple process. Elections are statutory processes. An election is catered for from start to finish in the laws of Guyana. Specifically, Chapter 103 of the laws of Guyana, the representation of the people. There are other pieces of legislation which capture other aspects. For example, the National Registration Act, which deals with this ongoing claims and objections period and so on. A resort to the strict following of those pieces of legislation, following the tenets of the law, can quickly remove the debris from the road, remove the unwanted traffic, remove the crowds on the road, and let us see a clear path to elections. But like I said, for some strange reason, person or persons within that organization do not seem to want to have that clear path. And that is why we find ourselves in this position. But all is not lost. That is for sure. There is still enough there for us to move forward with and to ensure that our path and our quest for credible elections is met in a timely manner.
Thank you very much for being here, Sis Conrad, Commissioner of the Guyana Elections Commission, representing the opposition. Mr. Robertson Ben, a Commissioner also, representing the opposition. For your time and to bring to the public these issues that are existing. I think people are going to be particularly concerned about the issue of names being removed from the list, as well as the whole confusion with regards to two lists out there. So I thank you for your time, being here to explain and to bring clarity, and I hope that you can return some other time to continue to update the people of this country and let them have a clear understanding of what are the challenges and how do we work to eliminate them. Thank you very much.
Thank you.
Thank you.
And thanks for watching.